Okay, let's get right into this. We had to restart the video because the prior video was having some issues when it comes to quality of video. So this video is about specifically SSR 24-3P. And I'm actually finishing up my brief. And I'm doing this video because I have to go ahead and supply a brief for a hearing that I did where somebody's actual benefits are in the balance of this situation. So this is a life and death situation for a person seeking disability benefits. And what happened was there was this rule that Biden released, and it was called SSR 24-3P, and it was effective date of January 6, 2025. And when that happened, right, when this whole thing came down, nobody really thought that much about it. It wasn't that scary. It wasn't that big of a deal. It just wasn't like, holy cannoli, this is whoa. So as a result of that, everything just kind of kept plodding along. And then I had a judge that was in a part of the country that I don't always have judges in. It's just not a place where I have zillions and zillions of hearings. You know what I mean? Like Texas, I have a lot. Florida, I have a lot. Stuff like that. But this was like, kind of out there. So when I had this hearing, it turns out the vocational experts in that area were specifically not citing to jobs. Why is that important? Because you have 5 elements to be found disabled. Element 5 of those 5 elements is, can you do any other work in the national economy? And then they normally give 3 jobs at least. Could be 6 jobs, 9 jobs, whatever. Depends on how many hypothetical questions they're going to be asking during the hearing. So the whole point with this was that I did a hearing and the vocational expert did not offer a single job. Only categories of jobs that the claimant could hypothetically potentially do in the national economy. Now, as an attorney, my job is to try and beat the jobs that are proffered during a hearing, right? So, the whole point of this thing is I sit back and I go, okay, how can I go ahead in this situation and try to beat essentially, these jobs that are presented by the vocational expert that the judge may be relying on to deny a claimant? How do I beat these jobs? Well, if they don't offer any jobs and they only offer categories that that person could do, well, those categories could have 5 jobs, 10 jobs, 15 jobs, 20 jobs, 30 jobs, 1,000 jobs, 500,000. Well, that's not going to have that, but it could have a lot of jobs. So me as the attorney representing a claimant, I'm not able to beat that, because if all they do is offer categories where they potentially got data from and there's no jobs that they actually tell me, I can't beat the jobs then, because all I have are categories. So during this hearing, which is a life and death situation for this person to be found disabled, have the money, be able to survive, I said to the, judge, Your Honor, where are the jobs? And the judge said, well, ever since they came out with the new policy interpretation, ruling the new case, the new this, that, yada, 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 people have been pretty consistently, the vocational experts, utilizing this, new way of doing things, which is where they proffer jobs that essentially, are just categories. It's a category of hundreds of jobs. And that's a big problem, because if that's the way it's going to be, no law firm will ever take a claimant under 50, ever. Because if you don't have grid out options to back you, you will never take a claimant under 50. And you will see a massive amount of disabled under 50 people, homeless and starving. That's literally the last Biden rule that really went through, other than the Social Security Fairness Act, may have damned significant amounts of disabled people that were under 50 years old. And nobody's talking about it. You know why? Because the judge said to me during the hearing, none of the other attorneys had complained about it. Let me ask you this, okay? Let's say this. Let's say you go into a hearing, right? The vocational experts, they're the job expert. And all they do is they say, well, you could be doing a construction style job. You could be doing a landscaping style job. You could be doing this style job, that style job, whatever. You could be doing all these different, but they don't give you specific jobs. Then how do you argue against categories of jobs? You need to beat the specific jobs that are proffered. So anyways, I'm going to go through this real quick, but I want you to understand this is something that is going to change the face of Social Security disability benefits. And I'm sure Trump would allow it to continue, because it means fewer people are found disabled. And, when you got to cut back on benefits and cut back on people, and you got to cut back on all those things, bottom line is this helps him towards that agenda. Now, I'm going to go ahead and give you a little side note here, okay? So you kind of understand some of the basics. There is a specific rule that doesn't allow this. The rule is under 20 CFR section 404.1566E, and it states, Use of vocational experts and other specialists. If the issue in determining whether you are disabled is whether your work skills can be used in other work and the specific occupations in which they can be used, the specific occupations in which they can be used, or there is a similarly complex issue, we may use the services of a vocational expert or other specialist. We will decide whether to use a vocational expert or other specialist. The code requires under 20 CFR 404.1566E that they give specific occupations. Let me give you another one. 20 CFR section 416.966E, use of vocational experts and other specialists. Again, repeats, if the issue in determining whether you are disabled is whether your work skills can be used in other work and the specific occupations in which they can be used, or there is a similarly complex issue, we may use the services of a vocational expert or other specialist. We will decide whether to use a vocational expert or other specialist. So the code requires, to be fair with this situation, okay, that you have to, during the adjudication, use specific occupations. And if you don't use specific occupations, then you don't meet the code. So they got to find jobs that you could do to screw you out of benefits, to say, no, you can't have them. And they look at it in a different way, and that's pushing it. But, they look at it in the way of like, well, we're going to use these jobs and we don't think you're disabled because you have the capacity to do these jobs. And remember, it's not just people, okay, that are basically, in a situation where, it's not just people applying for benefits. People who recently found disabled now, as of the end of Biden's term, have this new rule that applies to them. So the point that I'm getting at here is that this is going to, if they don't give me what I'm demanding here and saying that they have to give me specific jobs that they're going to try and use to deny my claimant or potentially approve my claimant, right? It could go either way. If they don't give me specific jobs, then there's no law firm on planet Earth that would be willing to take Social Security, disability insurance, or supplemental security income claims of people under 50. Because if you don't have the grid out option as an option, it ain't happening. All those people who apply, who want to get benefits, you will see significant amounts of people living on the street who can't work, who are under 50 years old. Okay, and that's the reality. They won't be able to get benefits because of this. Now, let me read to you the specific rule so that you can understand exactly what's going on here, because this thing is a benefit killer if they keep using it the way they've been using it. All right, policy interpretation ruling, effective date January 6, 2025, Federal Register, Volume 89, number 235, page 97158. SSR 24-3P, use of occupational information of vocational specialists and vocational expert evidence in disability determinations and decisions. In other words, using a job expert to say whether or not somebody could get a job and work a job. All right, here we go. Purpose. When we make disability determinations and decisions, we may ask impartial vocational specialists. Those are the people who basically look at the file and tell the judge or the DDS rep whether or not you could potentially work in the national economy. But they're not the ones you see in the hearings. The VS, the vocational specialists, they're in the background. So we may ask an impartial vocational specialist, they're the people in the background, or vocational expert, those are the ones at the hearing, to provide evidence about work. VSs and VEs give us evidence tailored to the specific facts of the cases about which we consult them, based on their professional knowledge, training, and experience in the vocational data available to them. All right, so that's a cutesy sentence, but here's what you need to know. They spent almost they spent $500 million trying to develop a new book system to replace the DOT. They realized they were just throwing money and it wasn't going anywhere. They weren't getting a product to use to replace this very old book called the Dictionary of Occupational Titles. It's like the early 90s was the last time it was updated. All right. So it's just not a good book anymore. It doesn't make sense anymore. I mean, it's valid in the sense of like it has jobs, but a lot of the jobs in it are not performed the same way they were, because when you add internet, when you add touch screens, when you add all of those modern features, a lot of those jobs just don't, there's no addresser. There's nobody sitting there putting stickers of addresses on envelopes anymore. There's no addresser, okay? It's all done by a mass printing machine. Now, the point is, this book, this Dictionary of Occupational Titles, it's not reliable in the sense of modern day, can this person fulfill these jobs? Because these jobs are super old and they haven't been updated. So the SSA is looking at this saying, well, we don't want to throw more money after this $500 million we've already thrown at this other book that we never completed. We don't want to throw more money. So why don't we just open it up to other books that we already use and let the vocational experts provide information from other books? Okay, here you go. In 2000, we issued SSR 00-4P, which explains that before relying on VS and VE evidence to support a disability decision, our adjudicators must, number one, identify and obtain a reasonable explanation for any conflicts between occupational information provided by a VS or VE, the job experts, and information in the Dictionary of Occupational Titles, including its companion publication, okay, the selected characteristics of occupations defined in the revised Dictionary of Occupational Titles. All right, so in other words, what they were saying back in the day was, look, vocational experts, look, job experts, if you essentially give us testimony that's not consistent with the book that we've been using forever, you got to tell us why it's inconsistent, okay? And number two, explain in the determination or decision how any conflict that has been identified was resolved. So explain why you have this differing opinion. This is the old rule. And, give us some meat as to the explanation so that, the conflict that's been identified has been resolved. So that it makes sense why you would say something that is counter to, not the same as what the Dictionary of Occupational Titles has, the job book. Okay, cool. We continue to recognize the DOT as a valid and reliable source of occupational information, and we will continue to use it in adjudication. However, we acknowledge that the DOT is not the only reliable source of occupational information. We note that recent federal statistic data relating to work in the national economy uses the Standard Occupational Classification (SOC) system, and that the SOC system for classifying occupations is different from that of the DOT. The requirements of SSR 00-4P, this is the old rule, make it difficult to use these other sources because it is not clear how a vocational expert or a vocational specialist or adjudicator can fulfill the requirements to identify and resolve conflicts with the DOT when primarily using a data source that is structurally very different from the DOT. All right, so what are they saying here? What they're saying here is, look, everybody's used to using the DOT, the Dictionary of Occupational Titles, the big job book. But it's really old, and we'd prefer that they have access to more modern information to make these adjudications seem realistic and not total BS. So we want you guys to be able to use this other book called the Standard Occupational Classification System. But the Standard Occupational Classification System, it doesn't really line up with the DOT. In fact, the jobs aren't all the same. The numbers aren't all the same. The two books are different. Now, one would say they should stick with one book, but that's not what they're doing here. They know they have a major problem here. And the major problem is they've been relying on a book that's ancient, hasn't been updated in over, Christ, I don't know, probably almost 35 years. Almost 35 years now. Hasn't been updated in almost 35 years. So they've got a problem. And the problem is not going to resolve itself because, nobody's going to rewrite the DOT. So what they're saying is, how do we get around this? Well, we could go ahead and just give them some other sources and let them use them. And that's what they're doing here. They're saying, we give up. We're not going to create a new book. Just use other sources and deliver information. That's what they're saying here. All right. We do not want to discourage use of occupational information that is reliable and commonly used in the vocational profession. In addition, our adjudicative experience since we issued SSR 00-4P has shown that requiring our adjudicators, VSs and VEs, vocational job experts, to identify and explain conflicts with the DOT is time consuming. At the hearing level, the requirements of SSR 00-4P have led to unnecessary remands to resolve apparent conflicts that were not identified at the hearing when the VE testified, and the requirements of SSR 00-4P might discourage vocational experts and vocational specialists from using occupational data and sources other than the DOT. So what they're saying here is, look, we don't want to spend more money on a book that we're not going to finish. And we've been working on it for a long time. $500 million spent on this thing. Book didn't get finished. The Great Job novel never got finished. So in realizing that, they're like, hey, we're going to say the DOT is still a reliable book, even though it's not. It's clearly not. It's obviously not. It hasn't been updated in decades and decades, right? And we're going to say, okay, you can also use these other books. And when we say you can use these other books, we, in our heartfelt approach, in our heartfelt, loving, procedural policy snuggling blanket, inside that little waffle of a moment, they're saying, you know what? We think you guys should be able to use other sources because we think maybe these other sources might have something in them. Okay. This ruling explains our standard for evaluating whether vocational evidence is sufficient to support a determination or decision. We are rescinding, we're getting rid of the old rule, SSR 00-4P, and will no longer require our adjudicators to identify and resolve conflicts between occupational information provided by VSs and VEs and information in the DOT. Let me read that to you again because this is life-changing. Okay. Remember, for those of you found disabled 1,000 years ago, this isn't going to directly affect you because this wasn't part of the rules when you were found disabled. Okay. So, and again, like I've said a million times, the people found disabled 20 years ago, 15 years ago, even 10 years ago, you were found disabled on an extremely liberal program. You know, it gave disability benefits to a lot of people who really were not severely impaired. And, you know, that's why you saw so much fraud. Okay. Some of you will say you're definitively impaired, and I believe you. But at the end of the day, there were a lot of people approved that should have never gotten a check. Okay. And a lot of those people, if they, you know, basically had to apply for disability benefits nowadays, they wouldn't get them. It just wouldn't happen. Okay. This ruling explains our standard. Okay. So here we go. We are rescinding Social Security ruling 00-04P and will no longer require our adjudicators to identify and resolve conflicts between occupational information provided by vocational specialists and vocational experts and information in the DOT. So what they're saying is we have given up on the DOT being reliable, even though we're saying in this writing that we still feel it's reliable. But we know it's so unreliable that we're not going to make the vocational experts explain why it's unreliable anymore. We're not going to have them tell us about the new computer systems and the new systems internally of how a job would be done nowadays and how they'd have new modern AI and new modern scanning technologies and all those things. We're not going to require them to do that because the DOT is so old that it's not really reliable. And we're just going to rely on this until we figure out a way to get away from the DOT in total. That's what they're really saying here. Okay. They're going to write in this writing, hey, we still believe in the DOT. We think it's reliable. But in reality, they're doing all this BS-y foot wiggling to get away from the DOT as best as they can, as fast as they can. All right. Pertinent history. We use a 5-step sequential evaluation process to determine whether an individual is disabled. We may use vocational specialists or vocational expert evidence as steps 4 and 5 in that process. At step 4 of the sequential evaluation process, we consider whether an individual, given their residual functional capacity, can perform any of their past relevant work, PRW, either as the individual actually performed it or as the work is generally performed in the national economy. If we find that the individual can perform any of their PRW, we will find that the individual is not disabled. If the individual cannot perform any of their PRW, the past relevant work, we go to the 5th step of the sequential evaluation process. All right, let me explain what this part is. Okay. Is element 4, they ask, could you do your past work? If it's just, if you can't do it, and they believe you, they take you to element 5. In element 5, they ask, is there any job out there that you could potentially do? right? And the older you get, the less of an expectation they have of other jobs, right? When you're over 60, they don't have expectation that there's other jobs out there that you could potentially. All right. In this sense, as we get deeper into this situation, I want you to kind of understand what's happening here, okay? Because this is something that could kill benefits for a lot of people. The opportunity to obtain them, and when you go through a CEDR, removing your benefits once you've already had them. Let's keep reading. At step 5 of the sequential evaluation process, we consider whether an individual's impairments prevent them from adjusting to other work that exists in significant numbers in the national economy. Considering their RFC and the vocational factors of age, education, work experience, if we find that the individual cannot adjust to other work, we will find that the individual is disabled. If we find that the individual can adjust to other work, we will find that the individual is not disabled. This is called a vocational allowance. It's an element 5 allowance. It's the last element on the trail to disability benefits. If you beat it, you get found disabled. But it is the cleaver element. It is the element that keeps the most people from getting those benefits. Now, what are they saying here? They're saying, okay, if you want to be found disabled, we're allowed to look at every job everywhere in the United States, every job everywhere in the United States, and see if there's any job anywhere, everywhere in the United States that you could potentially do at full time. And remember, full time doesn't always mean 40 hours. Okay. It doesn't. All right. In appropriate instances, we use the medical vocational guidelines to decide whether work exists in the national economy. When an individual's RFC, residual functional capacity, their ability to do stuff, walking, standing, pushing, pulling, crouching, remembering, focusing. When an individual's RFC and vocational factors of age, education, work experience correspond to a rule in the medical vocational guidelines, that rule applies and directs the decision of disabled or not disabled. Those are called the grids, right? All right, where our finding a fact about an individual's RFC or a vocational factor does not correspond precisely to a medical vocational rule, the guidelines provide a framework to guide our decision making. Our regulations state that we will take administrative notice of reliable job information. So in other words, you notice that? You notice that little sneak in right there? Let me read it to you again so you don't miss it, okay? Our regulations state that we will take administrative notice of reliable job information. That's why at the very beginning of this new Social Security ruling, they had to say that they still believe the DOT is reliable information. But they don't actually really believe that because it has not been updated for decades, and they're updating the rules to this new rule because they can't just rely on the DOT to deliver information. Instead, they want vocational experts to have access to the SOC, which tells us that they believe more in that book of business when it comes to a book that tells them jobs than the DOT. Okay, so you're starting to see inside the game that's being played by the SSA because they want to move away from the DOT specifically to this other book. And the other book doesn't really mean good times for the disabled. All right, so here we go. In certain cases, we use VSs, vocational experts and vocational specialists, as sources of job-related evidence, including evidence about whether an individual's work skills can be used in other work, the specific occupations in which they can be used, or a similarly complex issue. Once again, individuals' work skills can be used in other work. Other work means specific other jobs, okay? The specific occupations in which they can be used. The specific occupations that can be used, or a similarly complex issue. So what they want to explain here is that they are stating that they have to provide, and the vocational experts aren't doing this right now, they're starting to get away from this. They have to provide specific jobs in the national economy that you could potentially do. Otherwise, they're just going to provide basically, categories of jobs. How do you beat that? How do you beat a category of jobs? You'd have to take every single job and write how the claimant wouldn't be able to do that. Let's say that there was 30 jobs in a category. It would take too long to brief it. I mean, it's a brilliant way to get people to get, denied. It's a brilliant way to do it. But, I've been doing this too long. I've been doing this for a very, very long time at this point. So as a result of that, this is how they're doing it. This is how they're transitioning away from the DOT to other sources. And it's going to decrease the amount of people who are under 50 that can apply and successfully win disability benefits. Our regulations state, okay, so we went through all of that. All right, VEs and VSs may use any reliable source of occupational information that is commonly used by vocational professionals and is relevant under our rules, along with their professional knowledge, training, and experience. VEs and VSs may use a combination of these sources when providing occupational evidence. Adjudicators must weigh the VE or VS evidence in the context of the overall record and determine whether it can support a conclusion at step 4 or step 5, right? Element 4 or element 5. Policy interpretation. Okay. The DOT, the Dictionary of Occupational Titles, the big book that they've been using all along to cut people off from getting benefits or allow them a vocational allowance. Our rules, such as regulatory terms and definitions, and our guidance are controlling for our adjudicators. The DOT, which, as noted above, we continue to take administrative notice of as a reliable source, corresponds to many of our rules and guidance. They've got to say that, because if it's no longer reliable and they don't say it's reliable, they got to kick it to the curb. And they're not willing to kick it to the curb yet because they don't have a flight path to get away from it. They're trying to do this to get away from that book. For example, the maximum requirement of occupations is generally performed in the DOT correspond directly to our rules and guidance. We classify jobs as sedentary, light, medium, heavy, and very heavy using, let me get this page over here. Hold on. There you go. Boom. Using the same meaning as those terms have in the DOT. So in other words, the system that we traditionally use to approve somebody for benefits and they live a better life, or deny somebody and they go homeless, is this book of, jobs called the DOT. It's pretty parallel and pretty linear with what the SSA has in their statutes. Our categorization of skills also corresponds with the DOT. The DOT lists a specific vocational preparation, SVPs 1 through 9, an SVP level for each occupation it describes. Our skill level definition in 20 CFR 404.1568 and 968 of unskilled, semi-skilled, and skilled work are corresponding to the DOT SVP levels of 1 to 2, 3 to 4, and 5 to 9. All right, so if you don't know what that means, specific vocational preparations is how they measure how skilled your job is. They measure that by how much time it takes to learn that job. A job that only takes a short demonstration or like a month, you're looking at SVP 1 and 2 categories. You start increasing the time of how long it takes, you're in the 3 to 4. That's semi-skilled. So unskilled 1 and 2, semi-skilled 3 and 4, and then skilled basically 5 to 9. You look at 9, that's a job that takes 10 plus years to learn how to do. Okay. It's like a judge job or a rocket scientist. Okay. We may ask VSs and VEs to offer examples of other occupations an individual can perform. Now they're saying here they may ask them. They may ask them, and that's true. They haven't always provided, potential jobs. But usually what that means is that they're ready to go ahead and either approve them or deny them. But we now know from this other statute that they've got to provide occupations that are specific. Okay. Additionally, VEs may offer estimates of the number of jobs that exist in the national economy in such occupations. We do not dictate any specific approach to estimating job numbers, and the numbers provided are only general estimates. Our adjudications are non-adversarial, which nobody believes but them, and we process millions of cases each year. I mean, look, guys, it's non-adversarial because to them, it doesn't follow traditional rules of evidence, and the judge is not supposed to be opposing counsel. It's not supposed to be a situation where they are beating you up in cross-examination. I would say about 50% of my hearings are with certain absolute definitive nature, a back and forth of examination and cross-examination. They're not all like that, but half of them are. And you'll know that because all of a sudden the judge will jump in, right? And then I'll go back to my question. Judge will jump in. Judge will finish. Say, any additionals, counselor? Any additional attorney Hnot? Yes, Your Honor. Let me ask about specific environmental limitations in the national or in the work environment that might limit the claimant going forward for these types of jobs, right? And then it's a back and forth. It's a back and forth. Okay. So these VSs and VEs may provide evidence based on their professional experience and any reliable source of occupational information that's commonly used in the vocational profession and relevant under our rules. VSs and VEs are in the best position to determine the most appropriate sources of data to support the evidence they offer. We expect VSs, vocational specialists, and VEs, vocational experts, to identify the sources of the data they use and, where applicable, to explain their general approach to estimating job numbers. If the VS or VE uses a data source that defines exertion, education, or skill levels differently than our regulations, we expect them to explain the difference. We may instruct them to address other concerns as needed. For example, they should identify and explain if they cite an occupation that is performed in a different way than identified in the source of data they used. Because VEs and VSs are impartial and qualified professionals whom we consult because of their expertise, a more detailed inquiry into the sources of data or approaches used is not usually required. Let me read that to you again. Because VEs and VSs are impartial, they're so impartial, yet they are trained with specifics of what they have to say at each portion of the hearing so that their opinion can't be overruled. Remember, so look, here's the thing. Who pays for the VSs and the VEs? The Social Security Administration. I'm not saying that they're biased as a result of that. Who trains the VEs and the VSs on specific language that has to be incorporated into the SSA's documentation for a proper adjudication? That would be the SSA. Okay, so I'm not saying that makes them biased. I'm not saying they're biased. Do the VEs and VSs have a natural connection with the adjudicator by doing claims over and over with them? Yes. Does that usually create bias? Absolutely. But again, I'm not saying that this would create, an unnatural, neutral, situation. But, when an expert is consistently paid by, trained by, and working with one particular side, you really almost never end up with a lack of bias. You usually have an abundance of bias that occurs. All right. So, all right, let's keep reading. For example, they should identify and explain if they cite an occupation that's performed in a different way than identified in the source. Because vocational experts and vocational specialists are impartial and qualified professionals whom we consult because of their expertise, a more detailed inquiry into the sources of data or approaches used is not usually required. So, in other words, to put it very simply, because they're professionals and they were trained by the SSA of the requirements to give testimony before the SSA, and they're paid for by the SSA, and they have personal and repetitive relations with those who adjudicate these claims at the SSA, a more detailed inquiry into the sources of data or approaches used is not usually required. That's the problem. That's a problem. At the hearing level, when the claimant is represented, we expect the representative to raise any relevant questions or challenges about the vocational expert's testimony at the time of the hearing and to assist in developing, the record through appropriate questions to the VE. Let me read that to you one more time. See, and this is what's so interesting to me. When you guys go to a hearing, when you go do like an actual hearing with a judge, a federal judge, like most of you have no idea all the sections that actually occur to this thing. Because when you go in there and do the hearing by yourself, there's entire portions of this where you're just cut out because you don't know how to communicate. You don't know how to cross-examine somebody. You don't know how to, basically ask questions of the vocational expert. They require in this rule that you cross-examine the vocational expert for issues then and there. If you don't, you effed it up. Malpractice. You effed it up. Now, think about that from a quick perspective. What other court system makes you then and there, magically, consistently, every single hearing, figure out exactly how you want to formulate your attack plan for arguing against the theories of the vocational expert? It's not realistic. An attorney can't always nail it. They can't be perfect every time. It's just not going to happen. But under this rule and regulation, I will read it to you again. Here we go. At the hearing level, when the claimant is represented, because if they're not represented, they don't even go to the claimant. They tell them to be quiet. If the claimant is represented, we expect the representative to raise any relevant questions or challenges about the vocational expert's testimony at the time of the hearing and to assist in developing the record through appropriate questions to the vocational expert. So just to make clear, like if you went into one of these hearings not having an attorney, you would skip an entire portion of basically counter arguments to try and help you win. You wouldn't even be part of that section. Like you're just cut out. Now, and this is always the part where somebody's like, well, I didn't need an attorney. I got approved. And it's like, guys, there are people who are like super, super, super disabled and they get approved and they don't need an attorney. And what's sad about that is when they do that stuff, they're like, I didn't need anybody to get approved. There's, 20, 30, 40, 50, 60, 100, 150, 200, 2,000, 5,000, 10,000 people who didn't get approved that then feel like crap because so-and-so got to play at the playground and they didn't. So-and-so got to have a check and they didn't. All right, so here's the deal. Based on the vocational evidence in the case and the record overall, an adjudicator will determine whether the evidence provided by a vocational expert or vocational specialist is adequate to support a decision in step 4 or 5. And, remember, they've worked it out all ahead of time. They send out notifications about, what they expect and what the training requires and what example statements would be in a hearing. They train them. Again, they are supposed to be neutral, unbiased, but they train them, right? Some sources of occupational data use definitions of exertion level, skill level, and education level that align closely with our program rules. A DOT is such a source. If a VS or VE uses a source that defines exertion, skill, or educational level differently than our program rules, we expect the vocational expert to acknowledge the difference and explain whether or how they have accounted for the difference. So what they're saying is, look, we still want vocational experts to give some meat to why they said something, because otherwise we're just, nilly-willy accepting everything that they say, and that's not the way we want to do it. In addition, the job experts may cite to multiple acceptable sources. This is the new rule, because remember, back in the day, like January 6th, technically January 5th, they weren't allowed to do this. This was a Biden rule release. And to be really fair, it's going to hurt a lot of disabled people. And to be fair, it has been really interesting. Every time I talk about something Biden did when it comes to disability benefits and changing rules and passing rules and being okay with Social Security rulings being passed and, working with the commissioner on stuff, taking phone calls from the commissioner on what the direction is going to be. Every time I bring up Biden, it's always, well, he didn't know. Well, he wasn't aware. Well, he wasn't present. Well, he wasn't doing this. At the exact same time of this, at the exact same time of this, he was signing the Social Security, well, he might have been auto-penning it, but signing the Social Security Fairness Act. So he was very aware of what was going on with the Social Security Administration and the commissioner at that time. He was hyper aware of it. In addition, the VS or VE may cite to multiple acceptable sources. That's new. They used to be limited. Of occupational data that do not precisely correspond to each other. In some instances, it may be necessary for the VS or VE to explain how they accounted for the differences in classification. For example, federal agencies that collect occupational data now use the SOC system. One difference between the DOT and the SOC system is that the SOC system aggregates occupational data at a higher level. Sorry, it's tiny font. While there are some SOC codes that correspond to a single DOT, other SOC codes may correspond to a large number of DOT codes, and this is where the problem is. While there are some SOC codes that correspond to a single DOT code, other SOC codes may correspond to a large number of DOT codes. Put another way, a category of potential jobs that the attorney can't beat because there's too many potential jobs. So you can't beat one job by arguing against it. Now you got to argue against 30 jobs in a category. It's just not plausible. It's just You would have to have attorneys getting paid 3 to 4 times as much to represent a claimant to be able to do all those functional things with writing a brief. That's the only way it would happen. VSs and VEs may rely on occupational sources that use the SOC system. Examples of these data sets include, but are not limited to, the U.S. Bureau of Labor Statistics, Occupational Employment and Wage Statistics, and the Occupational Requirements Survey, ORS. For example, VEs may cite occupations from the DOT, but derive estimates of job numbers from the OEWS when providing evidence to use in our hearing process. Because the Dictionary of Occupational Titles uses a different classification taxonomy than the SOC system, vocational experts would need to explain the general approach of how they compared the DOT data to the data about estimates of job numbers in the OEWS. And it just talks about how they figure out there's 15,000 jobs, 1,000 jobs, 2,000 jobs in the national economy. Consider the following illustration. At a hearing, an administrative law judge presents a hypothetical question to a vocational expert regarding a younger individual with a high school education and no transferable skills who can perform a reduced range of light work. The vocational expert explains that the DOT and OEWS are data sources used for, let me make sure this is correct. Yep. Are data sources used for the testimony. The vocational expert then testifies that the hypothetical individual can perform work in the DOT occupation as fast food worker, DOT code 311.472-010. The vocational expert relies on their experience along with published comparisons between the DOT and the SOC to identify the closest related SOC group as 35-3023 fast food and counter workers. The VE explains that 5 additional DOT occupations crosswalk to the same SOC group. And it's not always just 5. Sometimes it's a lot more. And that OEWS data shows that there are 3,325,050 jobs nationally for the fast food and counter worker SOC group. Considering the limitations in the hypothetical question, the vocational expert explains that the fast food worker occupations occur more frequently in the labor market than the other 5 DOT jobs in the same SOC group. Then the VE states that the fast food worker occupation accounts for 1,300,000 jobs in the SOC group. The VE explains that the response was based on the VE's experience, training, observation of how the job is performed in multiple settings and industries, and familiarity with the job market estimates. So even in their hypo, where they say, well, you can provide a job category, they then say, but then break it down to the specific job that is linear with the DOT. So in other words, what I'm saying to you is there's a big problem. And a lot of you guys, I know you don't get this technical stuff super easily, or some of you do, but there's a big, big problem here. And at the end of the day, it means that no disability attorney is going to take 50-year-old or people under 50 years old, because the vocational, allowances are just going to die for those people. Because if they're allowed to just have categories of jobs, there's no attorney that gets paid enough to do Social Security disability law that's going to break down every single SOC code, potential job in a category. There's just no way. It's not going to happen. Let me go through the remaining of it. We're almost through it. And then you'll have actually cleared with me the entire new Social Security ruling, which was one of the last big things that Biden had, as with basically his, and this was after Commissioner Martin O'Malley. This is one of the last big things that, Biden had before he left the White House and the power to control the Social Security Administration. Biden, to me, was unfortunately a huge disappointment. There's a lot of Democrats that would be great options. They should always be the more popular party because they dictate the future. They innovate the future. They're just not doing a great job of it right now. Right now, they're literally trying to support 2 groups above all, right, which is Islam-based and LGBTQ+. Those 2 groups not compatible. And yet they're promoting identity for those 2 groups to be Democrats. It does not make sense that one group, one political party would choose a group that has complete opposing views to the point of actual terminal results. Terminal, you know what that means. It's just weird. It's just weird how off track they've gotten. I feel like the Democrats at this point are realistically where I felt the Republicans were when Obama first got in. When Obama first got in, I was like, man, Republicans are never going to win again. This guy's just too hip, too cool, too this, too that, saying the right things. The wrong thing is, if you look at early Obama, like when he was running the first time, the phrases and statements he's making are the same as Trump. The same as Trump. He was a middle person. And back then, that was a left person. But nowadays, that's the middle. So it's just really mind-rocking to see what's going on here. But again, Biden did not pass something here that really helped people. Biden, through the commissioner of the SSA and Social Security ruling, passed something that, to be fair, right, ends up hurting people under 50 massively from being found disabled. That's his legacy, and it's not a good one. Adjudicator responsibilities. Our adjudicators are responsible for evaluating the VS or VE evidence within the context of the overall evidence in the claim. If the job expert does not provide the expected information and explanation outlined above, the adjudicator, the judge, will usually need to develop the record with sufficient evidence to make a supportive finding at step 4 or step 5 of the sequential evaluation process. We will use this Social Security ruling beginning on its applicable date. We will apply the Social Security ruling to new applications filed on or after the applicable date of the SSR and to claims that are pending on or after the application date. This means that this SSR, Social Security ruling, on and after its applicable date in which we make a determination or decision. We expect that the federal courts will review our final decisions using the rules that were in effect at the time we issued the decisions. In a court, if a court reverses our final decision and remands a case for further administrative proceedings after the applicable date of this SSR, we will apply this SSR to the entire period at issue in the decision we make after the court's remand. So basically, if you get a remand, right, and it wasn't decided in your favor and you go up and then you get a remand back to the prior judge, they're applying this to you going forward. It's not good. It's not good at all. It's very not good. Okay. Now, we've gone through the grand majority of this thing, okay? And what I want you to kind of learn from this is that the SSA has a problem. They want to deny people who are too young when it comes to giving them disability benefits. And the reason why, okay, at the end of the day, right, the reason why at the end of the day they want that is that if you look at the math of a 30-year-old being found disabled and staying on disability benefits for their entire life, the massive amount of money that has to be paid to that individual significantly injures the Social Security Disability Trust Funds. So the way they kind of dance around the actual bottom line, not spoken idea is that if they can approve fewer people that are younger, or approve them with their kids, put them through an 18-year-old assessment for the adult rules, and then kick them off, then the system will continue to exist and last longer. Now remember, Social Security disability insurance benefits, the ones you pay for, are paid for by the workers, including you, the working force. They are not the same as supplemental security income. Supplemental security income will technically never run out because it comes from general taxes, unless, of course, they don't have enough for general taxes. Put another way, if they don't raise the spending limit. If they raise the spending limit, SSI gets, continuation of payment because it's got to come from those general taxes. If, however, they don't raise the spending limit, which is where they're at now, they can't. They devalued the dollar to the point where Moody's has now started to take away the rating that we have as a lendable country, as a bankable country. If they don't raise the spending limit, SSI people run into a very big problem because their money is supposed to be promised from the federal government, which can no longer afford its bills. So, with all of that in mind, keeping this in mind, okay, This new system, if it keeps being applied where they don't do specific jobs, is going to significantly reduce the amount of people who are found disabled between 18 and 49 in the day before 50. I know that some of you do not feel that that is fair. But, and I think this is important, this is no longer about fairness. It's a war. Social Security Administration is tied to a government that's a sinking ship. Now, look, I mean, Trump just got 3 new trade deals done. You know, we're talking trillions of dollars. He's doing the right stuff. I'm not trying to make it like a pro him thing, but like from a business perspective, and I know SSI people like don't usually have an education in trade, dollar, you know, reserve currency, international finance, you know, how do we get products from here to there? How do we sell them? What do the tariffs do? All that stuff. I know that a lot of SSI people don't know that stuff. I know that a lot of SSDI people don't know that stuff. I know a lot of retired people don't know that stuff. But he's doing the right things. He's doing the right things to basically lower the cost of you going to the store and having to buy a can of soup, which is something that I think all disabled people can understand. And so as a result of this situation, either the SSA is going to change course with this, or there will be very few people being found disabled between 18 and 49 and the day before 50. I'm going to tell you something real quick, okay? The United States government is not a fan of people becoming disabled. Here's why. When people become disabled, the government is admitting that they're not able to earn enough to survive, so they give them a check. But what they're also admitting is that they are cutting off a pinky, a ring finger, a thumb, because they need more and more Americans to go ahead and work so that they can borrow against the amount that they go ahead and earn from their work product. So what America needs right now is a lot of workers working and paying taxes. But disabled people are the opposite of that. They're the ones who take from what they either paid in or never paid in enough of. So this is why I think realistically we are going to be seeing some rather aggressive steps against Social Security disability benefits in the future. This is why I am so concerned, because I know that at the end of the day, the number one groups of people that Trump is worried about, that Biden threw under the bus with this ruling, are the disabled. And let me tell you another thing real quick, and I think this is important, okay? This is important. You know how like SSI benefits, you get found disabled, you know, or you get them if you're a refugee, immigrant, that's an asylum seeker or trafficked or one of those individuals, right? The problem with that is that America during Biden's time had begun to fund for 7 years of SSI with a 2-year up option groups of immigrants that were allowed to come into this country that would riot against the success of the United States. They would riot and say, death to. They would riot and say, down with. They didn't have a job because their job was to either go ahead and receive an SSI check as a refugee, asylum seeker, an entrant, person who's trafficked, or they were disabled. And so the thing is, they were either a paid person to go out there and chant, or they were a paid person through SSI to go out there and do the same thing. And the problem with this whole thing is that it's not that Biden abused us all with this mass immigration thing. I mean, that's a huge issue. It sucks. It's not good. The real problem that nobody really talks about, and this is the issue here. The real problem that nobody ever talks about is that the middle class paid for the riots to occur, not because they wanted to, Not because they wanted to do that. It's because their general taxes paid for supplemental security income benefits that were then paid to people who then went out and rioted. Some of them were those individuals, not all of them, but it's a percentage. And that percentage shouldn't be like that. Sure, SSI people should be able to go out there and, protest and do things like that. Absolutely. Absolutely. But a lot of the anti-American rhetoric, a lot of the anti-American movement, it has a bunch of people in it that are receiving an SSI check, which is mostly paid for by the middle class, specifically the white middle class, which is then looking at this whole situation of their culture of work hard, earn money, have a decent retirement. That's the promise, right? That's the promise. That's the promise to Black people, Asian people, white people, Latino people. That's the promise, right? But on the other side, they're funding through SSI benefits, which is a 3-pronged program, over 65, disabled, or basically, essentially an entrant, refugee, asylum seeker, person who's trafficked, right? Who pays for that? It's the people who are terrified of it, the people who are moving out of cities and areas because of it. It's a really weird time. I don't know how to put it to you guys, but it's just a really weird time. And I'm hoping that the culture of people in the middle class gets to survive. I mean, we know it's got some problems, right? We know the middle class is getting eaten up by artificial intelligence. We know the middle class is getting eaten up by, basically robots, machines. We know the middle class is getting eaten up by, new computer tracking systems, scanning systems. We know the middle class is getting eaten up by new CMS programs, client management systems inside computers that can, organize and apply things faster and better than ever before. What's going to happen when there's not enough a big enough middle class to pay for the FICA taxes, your retirement, your disability benefits, the SSI checks going to those who are, some of them, out protesting? What's going to happen? That's why I'm trying to get you guys realizing what's coming up. All right. Anyways, I will catch you all at the next video. We'll rock and roll with it. It's going to be about those who basically were recently arrested related to Social Security benefit fraud. It's good to see it because you can learn like what they did wrong, so you know like how to not do that thing. I am Attorney Walter Hnot. Please remember to hit the like button. Please remember to like and subscribe. Head over to Google and type in Disability Resolution Law Firm or Disability Resolution Florida. I will catch you all at the next video. Please remember, I go live on Mondays and Thursdays. I will go live tonight to answer questions for free. And then after that, you should be good to go. Also, please remember there is a little mini 1-hour consultation or 30-minute consultation contract below where you can get access to my brain specifically for an hour or 30 minutes. I will catch you at the next video shortly. Give me about 5 minutes and we will rock and roll. Thank you so much, Attorney Walter Hnot, and we'll go from there. Bye-bye, everybody. Bye-bye.